right, we are recording again. Once again, my apologies to everyone on the call. We've been running into some issues with WebEx this morning, but we are once again recording. Mr. Erickson, if it's all right with you, I will just pick up where I left off. In fact, maybe I'll start at the beginning of my comments.
That would be fine.
All right, so we are here today on a rule-making hearing for 7.1.30, which concerns administrative hearings for civil monetary penalties issued pursuant to the Public Health Emergency Response Act. So back in March of this year, the department had adopted an emergency version of this rule that is substantially identical to what is being proposed today. There are a few minor changes to that I'll go over here in a minute. But in short, it was adopted as an emergency rule on March 20th, and the Public Health Emergency Response Act references the adoption of rules concerning hearing procedures. And so the thought with respect to this rule was to create pretty basic procedural standards, guidelines as to how these hearings will take place, and the abilities of the parties, and more specifically the ability of the hearing officer. So in these administrative proceedings, the hearing officer receives evidence, manages the conduct of the hearing, can hear motions from the parties about various things, and then ultimately the hearing officer submits a report and recommendation, a recommended decision to the Department of Health Cabinet Secretary, who then issues a final decision in all of these sort of quasi-adjudicative type cases. And so while the content of this proposed rule is not really taken entirely from any one given source, it is borrowed from material from various sources concerning administrative type hearings to establish pretty consistent standards with what we see in other administrative adjudicative type cases. And so that is, in short, the purpose of this rule. It's really to establish the procedures for what the hearings look like. The purpose of this rule is not to specify or detail all of the circumstances in which the department might proceed in issuing civil monetary penalties under the Public Health Emergency Response Act. And I do understand that, especially in the current climate and in the current situation with COVID, and given that the department has issued notices of contemplated action to various individuals, that is a hot topic right now. And I know that we've received multiple comments about that. It is not my intention today to delve into the subject matter of pending litigation. I will say that there is a pending case before the state Supreme Court. I understand that it is set for a hearing, I think, on August 4th, so we're hoping that we'll see a decision from the Supreme Court on that case sometime within the next month. But that case more specifically addresses the question of whether the agency can pursue civil monetary penalties against businesses and individuals under the Public Health Emergency Response Act. That is kind of the central question in that ongoing litigation. But this particular rule that we're addressing here today is really more specifically about the nuts and bolts of just how the hearings themselves will work and what the process is. And so with all of that being said, I will now go through the department's proposed exhibits 1 through 9. I will say that these exhibits have been posted on the Department of Health website. So if you go to Google and you type in Department of Health, New Mexico Department of Health Regulations, that should take you to a web page on the Department of Health website that includes 7.1.30 NMAC, and you should be able to see exhibits 1 through 9 posted on that website. They were posted yesterday. Several of the items that are marked as exhibits were posted prior to yesterday, so they are somewhat duplicative, but at least they're labeled so you'll know what we're talking about. I will also note that we did receive, I think, 2 or 3 additional public comments in the last 24 hours, and those may not yet have been posted on the website, but those are included in the materials before the hearing officer. And as the hearing officer stated a short while ago, we'll be leaving open the opportunity for public comment through the close of business, until the close of business today. So 5 o'clock today will be the end of the public comment period, but if anybody is interested in submitting more public comment, you can send it to the address identified in the hearing notice. So with that, Mr. Hearing Officer, I will go through the department's proposed exhibits briefly. Exhibit 1.
I'm going to interrupt you. Well, I just want to add and emphasize that I am not being asked to consider the authority of the department to impose civil monetary penalties in this proceeding. And I'm not being asked to consider anything about the amount of any fines that might be imposed as a result of a violation of public, as a result of error. The rules that I'm being asked to consider and make recommendations to the Secretary regarding really just go to the procedures that should be used for adjudicatory matters, not to the question of the authority of the department to impose fines. Okay, you may proceed with the exhibits now.
All right. So again, we have 9 total exhibits for inclusion in the record of today's hearing. The first is the emergency rule 7.1.30 NMAC, which was adopted March 20th of this year. And so that is the currently applicable Rule 7.1.30. Exhibit 2 consists of the transmittal documentation. So these are basically forms that are required to be submitted along with any rule that is filed with records and archives. And so this document consists of the transmittal form as well as an attached letter that describes the circumstances under which the rule was being adopted and the basis for it. And that is a letter signed by the Deputy Secretary at that time, Eric Chenier, on behalf of the Secretary. And it also includes some exhibits consisting of executive orders from the governor declaring an emergency in the state. Exhibit 3 consists of the proposed rule. And as I mentioned before, this is what is sort of on the table for today, and it is substantially identical to the emergency rule that was adopted in March. And maybe while I'm on this, I could just go through this briefly to explain what it is that the department has proposed to modify from the original emergency rule. So the modifications are identified as underlined text and struck through text. So anything struck through is text from the original rule that we're proposing to remove, and anything underlined is text that we're proposing to add. And so the first proposed edit to this is to modify the number of days within which the department is required to issue notice of the hearing. And so the original rule, the currently applicable rule, requires the department to issue notice of a hearing within 5 days. So according to rules of statutory and regulatory interpretation, that would be 5 business days. And we were proposing to modify that and extend it to 20 days, which would then be 20 calendar days. And the reason for this proposed modification relates to the ongoing circumstance, the ongoing declared emergency related to COVID. At the time that we had initially drafted this rule and adopted it, we had not anticipated the extent to which the business operations of state government agencies, and especially the Department of Health, would be impacted by the declaration of an emergency. And as we've seen at the outset of this epidemic, state offices were closed. Virtually all state employees, including those within the Department of Health, are currently working from home. That has created delays as far as the processing of mail, and also as far as the administrative staffing of the Department of Health offices. And so what we're seeing is that the date of receipt of a piece of mail can be vastly different from the date of actual receipt, the date that administrative staff actually see a piece of mail. And so that is the rationale behind that change. The next proposed modification to the emergency rule, to the existing rule, in this proposed rule, is to permit hearings to be held in whole or in part by telephone or live video at the request of either party and at the hearing officer's discretion. And this is a modification from the original current text, which states broadly with the agreement of the parties. And again, this is a proposed modification that relates to the current circumstance with COVID. What we're seeing, especially with the orders related to mass gatherings and the closure of government offices, it is very difficult, if not impossible in many cases, to hold in-person adjudicative type hearings in the current environment. And in fact, that's why we're holding this rulemaking hearing today via Cisco WebEx. So basically, this would permit either party, either the department or the appellant, to request that a hearing be held either telephonically or via video conference. Either party can request that, and then it's just a matter of discretion for the hearing officer whether to grant it. In some cases, I suppose it's also possible, as we've seen in some of our adjudicative type, our other adjudicative type hearings, that these hearings could be hybridized in some way to where if someone really very seriously wanted to appear in person, they might be able to, but certain witnesses would appear telephonically or by video and so forth. So this just leaves open that possibility and the possibility for hearings to be conducted either in whole or in part via telephone or via video. And then the next, and I believe the last edit that was made to the existing rule in the proposed rule concerns the powers and duties of the hearing officer. And in this passage, we included a reference to the ability of a hearing officer to require that parties submit proposed findings of fact and conclusions of law, as well as closing arguments. And then to differentiate that from the hearing officer's own proposed findings and conclusions for the consideration of the Secretary. And I know that we had received some comments about this. I think basically the point of this proposed edit is just to specify that it is within the authority of the hearing officer to require the submittal of these things. I suppose that if a party really, for some reason, really did not want to submit these things, I imagine that a hearing officer would say that was okay. But ultimately, this is a pretty standard practice in administrative proceedings, and so we felt that it was necessary to reference it. The original version referenced, of course, the proposed findings and conclusions of the hearing officer to the Secretary. But typically in these types of quasi-adjudicative hearings, a hearing officer will borrow material from what the parties themselves have submitted. While it might sound kind of burdensome, in our experience, even in cases involving pro se litigants, a hearing officer is generally able to explain what the nature of these things is. That findings of fact are basically just a description, a list of facts that the individual believes are relevant to why they believe they should win the case, essentially, and then what legal conclusions that the individual thinks are relevant for the same purpose. And so again, this would be something that would be within the discretion of the hearing officer, and it's a pretty standard practice within administrative proceedings, and really intended mostly just to make sure that all of the parties' arguments are on the record and that there's a full record of the hearing. And so with that, that's all of the proposed changes, I believe, to the existing rule. So going through the rest of these exhibits, the department's exhibit 4 is the notice of public hearing for today's hearing. And that includes, of course, a link to the Department of Health's Rulemaking's webpage and the information on how to access today's hearing. Exhibit 5 consists of an affidavit of publication in the Albuquerque Journal, and so, of course, this is one of the notice requirements under statute, and this is just to demonstrate that the notice was duly published in a newspaper of general circulation. Exhibit 6 is a similar affidavit. This is an affidavit of publication in the New Mexico Register, just to demonstrate that the New Mexico Register did, in fact, publish the legal notice in this case. Exhibit 7 consists of an affidavit by Sheila Apodaca, a notice that was made to the public related to today's hearing and related to the rule. Exhibit 8 is the letter appointing the hearing officer from June. And Exhibit 9 consists of the public comments received, at least as of yesterday at about 5 o'clock or 4 o'clock. As I say, the paper copy that is with the hearing officer has been amended to include the public comments that were received after that time. However, if anyone would like to submit other written comments by the end of business today, those will also be included within those materials at Exhibit 9 for inclusion in the record. And so with that, Mr. Erickson, I would ask that the department's exhibits 1 through 9 be admitted into the record of today's rule proceeding.
Thank you. Yes, the motion to admit the exhibits 1 through 9 into the record is granted. All right. So I think at this point we can now open up the hearing for public comments, and I'd like to proceed with that. And I'd like to remind you to please state your name for the record. I can actually see the spelling of it on my screen, so you don't need to worry about spelling your name. But if you're appearing on behalf of yourself, if you could just indicate that, or if there's some organization that you're representing, please let us know that as well. So we can go ahead and proceed with that. And Mr. Woodward, do you want to, I don't know what you need to do to invite the first speaker.
Sure. These web conferences are always a little tricky. I do see a list of participants here, and it looks like we have 1, 2, 3. It looks like we've got 4 members of the public who are on the hearing today. And so let's, Mr. Hearing Officer, if you would like, I could maybe just read off the name of each person and just ask them if they would like to offer comments. I guess when you're speaking, please make sure that you speak clearly and make sure to unmute your microphone when you speak. And with that, let's start with with Christopher Goad. Mr. Goad, you are on, and do you have any public comments you'd like to offer?
No, I don't. I just want to see what's happening. So, thank you.
Okay. Thank you. Chris Meckles, you are also on. Do you have public comment that you would like to offer? Mr. Meckles, can you hear me? I think you are still on mute.
Can you hear me?
Yes, we can hear you.
Yes, I'm not sure what public comment you're looking at this point, but an important thing at the beginning of this meeting is, do we have agreement what the hearing procedure is for today's public rule hearing? What hearing procedure are you using for today's hearing?
So this is the hearing officer speaking, Mr. Nichols. Am I pronouncing your name correctly, Nichols?
That's fine. Okay.
Okay. So I'm hearing what Mr. Woodward described as exhibit number 3, which are the proposed rules for administering hearings on civil and monetary penalties related to the Public Health Response Emergency Response Act. So the entire focus of what I'll be looking at is the proposed rules that we see in Exhibit 3, and I'll be making a recommendation to the Secretary as to whether she should adopt those rules or not. So
that's the question that I'm asking. The question I'm asking you, today's hearing procedure, this rule hearing, what procedures are you using for today's hearing?
Well, I think I indicated at the beginning of the hearing that I was conducting the hearing pursuant to certain statutes, and so that's what governs it.
I'm sorry, what statute did you just reference?
Well, I listed them at the beginning of the hearing, and I'm not going to repeat all of my opening.
No, I was having a lot of trouble getting onto this hearing. It was a huge mess just getting here. So I first missed that because it was so messed up getting here. The hearing procedure I'm talking about is something like, there's a default hearing procedure in this state, 2018, which is that unless you have a published rules hearing procedure, you are bound to use the default hearing procedure. Is that, in fact, what you're going to use?
I will look at that. But I'm following the standard procedures that we always use for these.
What is your standard procedure? You haven't published it.
Well, we're not going to have a discussion about that today, Mr. Meckles. You've had an opportunity to make comments, and you have written comments, and you have an opportunity to make oral comments as well. If you'd like to make a comment, that's fine, but I'm not going to be engaging in answering a lot of questions.
Sure, this is a part, and I did reference it, I believe, in my first written comment. I suggested that they make your hearing procedure that you're going to use today available as far as your exhibit, and they failed to do that. This is not a trivial question. I'm just saying if you're not familiar with the default hearing procedure, and you may not be because many of these departments don't use it, so they're bound to do it legally. There's like 124.25 as an NMAC. It's a mandate, unless you have a published hearing procedure, you're bound by law to use that one. And if you're not going to use it, if you're not even familiar with it, perhaps you should get familiar with it.
Well, I'm not going to turn this into a question and answer session. This is an opportunity for you to make public comments, and you can make public comments that are relative to the matter at hand.
Okay, I think right now we've got a problem because you're not using the right hearing procedure. The next comment I would like to make is that what I've suggested in my comments, it's to no effect apparently, is that the appropriate document to compare the proposed hearing procedure against is 7.1.2, because 7.1.30 is drawn from 7.1.2, which is the normal hearing procedure used by the Department of Health, which they could have well used as opposed to bringing this hearing procedure forward. But you can't really understand the procedure that you're proposing, which is 7.1.30, without referencing 7.1.2, which is the document from which you're hearing the proposed hearing, is gone. So by not bringing that as part of the exhibit, calling the public to compare the proposed hearing procedure to know if it's reasonable, unless they have the document from which it is gone. And you haven't brought that as an exhibit. I think you should stop right here and introduce an exhibit, which is 7.1.2, which is the hearing procedure, which is the basis of the procedure that you're bringing forward today. Without that, you can't really, because the way you would have us do it is to bring forward a hearing procedure, which was always showed up as an emergency hearing, procedure back in March, and you produced it with no examination, no involvement from the public. Now today you're bringing forward the hearing procedure just de novo and expecting us to comment on it, when in fact if it had been done in the proper hearing originally, you would have looked at the basis of that hearing procedure, which is 7.1.2. And I think today you should right now stop and introduce an exhibit, which is 7.1.2, so we can have a fair comparison of the basis of the procedure you're bringing forward.
Well, I'm not going to stop the hearing, and if your comments are duly noted, and if you'd like to make comments on the proposed rule that's at issue today, you may proceed with that.
The question I have there is, in past hearings, and I've been through a lot of these hearings over at the Law Enforcement Academy Board, what is your procedure going to be? Are you going to work your way through the whole proposed procedure one section at a time, or what is the plan, or do you want all the public comments right now?
If you have any public comments on the proposed rules, you may make those now.
Well, you want me to comment on the whole proposal right now at this point?
I'm not going to go, subsection by subsection through the rules. If you have comments that you'd like to make on any of the subsections, you may proceed with that.
I will be happy to do that, and I am prepared to do that. But I just didn't know that's not the way I've usually proceeded in the past. But I'm happy to do that. So, starting at the top, and what I'm going to do, and I assume this is acceptable, is I propose to compare your proposal, which is 7.1.30. And I propose to compare that to 7.1.2, because 7.1.2 indeed is the basis of 7.1.30.
Well, we've already heard from Mr. Woodward that there was no particular rule that was the basis for these proposed rules, but they drew from a variety of rules. I want you to be mindful of the fact that I'm going to give you a reasonable amount of time, but I would use your time judiciously.
Okay. Well, for starters, I would propose to start, first off, since you had it up for comment, Edward, and one of your exhibits is that you have proposed changes. Let me address those. You have three proposed changes, which was from the original 7.1.30 that you presented, and one that I would agree to would be, let's see here. Section 7.1.30.8.f, which reads powers of hearing officer. There's that section. The proposed modification is near the bottom of that paragraph, which adds the language require the parties to submit proposed findings of fact and conclusions of law, as well as closing arguments, etc. That sounds very innocent. And I think I caught the tail end of Mr. Woodward presenting that. The fact is, I have represented a number of people in hearings, in grievance hearings at the laboratory, Los Alamos National Laboratory, when retired. Requiring the parties to submit proposed facts and conclusions of law if they are not represented by counsel is very burdensome. So if you're faced with if your appellant is faced with is going up against an attorney who's quite familiar with this regime and it's customary in lawsuits to present a finding of fact and conclusion of the law. That's just the way it's done. But in a hearing like this, without representation, you have an attorney on one side presenting an vendor he's very familiar with, and you have the appellant who is unfamiliar with any of this, and he's totally out of his league. So I think that is a very unfair and very burdensome request, and I would refer you to the fact that language is not, and I repeat, not part of 7.1.2, which is the hearing procedure used for virtually all other hearings which are analogous to this 7.1.30 in the Department of Health are conducted through 7.1.2. And there's no reason that the Spirit Act hearing couldn't have been done under that existing hearing procedure, but they chose not to do it. So if you actually look at 7.1.2, you'd find that, which is the language, the equivalent language in and that is 7.1.2.33. And it has language that requires the hearing officer to produce findings of facts and conclusions of law. And of course, that's perfectly reasonable. That's what you would expect him to do. But to demand this of the appellant, and especially because the appellant is likely to be without representation, is very burdensome. And it's unheard of it because it's not reasonable. And the fact it's not reasonable is supported by the fact that that requirement is not present in 7.1.2, which is the hearing procedure that's used at the Department of Health for decades. It's well tested, and it doesn't have that language. So why was it added at this point? Good question. I object to it very strongly. That language should not be added. The other one starting at the top, which is enough of its three changes, which again were presented in a very confused manner because first off, the whole hearing procedure should be brought forward and investigated section by section because as far as the law is concerned, it is a new statute that you're proposing. I mean, you're taking up an emergency statute, an emergency NMAC, which you present as if it was existing. No, it was presented in an emergency hearing with no public input, so it should be examined in detail, top to bottom, not as you're proposing today, which is just to propose these changes to it. What are you proposing to change to? You're proposing to change to something that has no public input for the generator. The whole thing is highly irregular. So, looking at this 7.1.30, at the very top, what you have there is the right to hearing. Can you hear me? I just lost the telephone connection.
I can hear you.
My screen just went funny.
I can hear you.
Okay, I claim at the top, 7.1.30, 7.1.30.8 should be compared to 7.1.2.13 and 7.1.2.14. So that is the equivalent language in the normal hearing procedure used by the Department of Health. If you're going to look for something against which to weigh the language of 7.1.30, it's not hanging in thin air. You have to weigh it against some other reasonable standard. 7.1.2 is a reasonable standard long used, performing essentially the same function. And yet, and the other thing I'd remind you of, and it shows up in my comments, is there was a requirement in the statute, in the FAIR statute, at risk of being slightly off here, in section 17, which is 19, which is the hearing procedure, just the hearing procedure being developed again, says the legislature laid down in the statute, it's not like a hearing procedure. That's what we're about today. But also within 19, it refers to 17, section 17, which says that the hearing procedures developed, brought forth under the Rules Act, which is what we're doing today, is found by law to be reasonable. I suggest that to be reasonable in case of 7.1.30, you need something to compare it against to see if it is reasonable. But therefore, the comparison with 7.1.2 is crucial because it determines the standard of reasonable.
Mr. Knuckles, I need to interrupt you just briefly. Just so you know, in most rulemaking procedures, we've had a time limit of 3 to 5 minutes per public speaker for whatever comments they have, and that's actually worked very well. I've already given you much more than that. I will give you another 5 minutes, but then you'll need to cut off your comments. And there's a great deal of repetition in what you're saying, so if you'd like to address other issues within the next 5 minutes, go ahead, but I don't need to hear things several times over regarding the same issue.
What you say, sir, is reasonable if you were bringing forward a 7.1.30 for a slight modification. But if you brought it forward as a full document, then it would be customary, and I've done in many rule hearings, to work through the document one section at a time, and you're not doing that. Instead, you're greatly reducing the input from the public because you're saying is, I'm not going to let you do that. I'm not going to let you work through that document one section at a time. It's not a new document. Well, sir, it is a new document. That's what you're in denial about. Okay.
Well, I'm not going to argue with you. I've already explained what the procedure is.
Okay.
I'm
cutting. Now you've got me on 5 minutes. I understand.
I'm not cutting you off. I'm giving you 4 more minutes.
Okay, very quickly. Scheduling a hearing. The scheduling a hearing, one of the differences with 7.1.2 is this procedure says the appointment of the hearing officer is the department will appoint a hearing officer. In 7.1.2, the appointment of the hearing officer is open to challenge because it requires the hearing officer to be impartial. That's a key difference. That language is so different from 7.1.2 that I would say that this language is unreasonable, therefore it doesn't meet the requirements of the statute. Another key difference is there's no language within the proposed hearing which allows for a stay up to the hearing. Under 7.1.2, which is used for very similar procedures, there's language that allows a stay of any penalties until the hearing is had. By taking that language out of 7.1.30, you put the appellant at great risk, and for no given reason, you just removed it. What you've essentially done with here and through the body of this, comparing it to 7.1.2, is you strip out all the language that protects the appellant. It gives the appellant rights. You strip out all appellant rights because, which you could have just used 7.1.2, but instead you're using this one, which strips out all the rights to the appellant. So now you've got the hearing officer proposing, the hearing officer of their choice. You have no say, which is very unreasonable compared to 7.1.2. You're now you propose to bring, and just because we don't have much time, you bring at the end you have the on the way past it, just in case you just pulled this out of thin air, I reference section .p, which is the order of presentation and general rules. I would have you compare that with 7.1.2-27. It's exactly the same procedure. So the point you just pulled this out of thin air is personal.
So you have 1 minute left.
Yes. Just absolutely. At the end, perhaps the key to all this is at the end of this whole procedure, compared to 7.1.2, you submitted this decision for a final decision by the secretary, and given the secretary 30 days, or I'm sorry, 45 days to make a decision versus 15 days in 7.1.2. No explanation given. And worst of all, at the end of this hearing procedure, in 7.1.2.39, there is language that allows for judicial review. That has been stripped out of 7.1.30. So now you have the secretary making a final decision with no review, no appellate review. That is just outrageous. The secretary is appointing a hearing officer. There is no say. At the end of it, they make a final decision with 45 days, and it is not appealable. And this is called reasonable when compared to 7.1.2. It is totally unreasonable, sir, and therefore this whole thing is bogus.
Okay, sir, your time is up. I meant to ask you, I did ask you earlier, but are you appearing on your own behalf, or are you representing some individual or group?
I'm appearing on my own behalf. But I have a lot of experience in this stuff over at the Law Enforcement Academy Board. I'm
simply asking whether you're appearing on your own behalf or representing.
I'm appearing on my own behalf. I'm a retired former fellow.
Thank you. All right. Mr. Woodward, our next public commenter.
Yes, let's see. It looks like I think we'll go to Scott Weiland. We have Scott Weiland on. Mr. Weiland, were you interested in making public comment?
I'm a reporter with the 7.1.30 NMAC. I'm just mainly just monitoring this to see what was going to be discussed. If you wouldn't mind clarifying one thing that I missed a little bit. So you said something, and I think the last gentleman referenced it, is it the review time, or when a challenge is submitted, something about 20 days, was it extended? I'm just trying to get that. I just want to get that clear. He said that there's a lag between often when someone mails in their challenge to let's say the fine, and when staff gets it. So what is it? Is it some kind of time for the hearing to be set up? What was changed exactly?
Yes.
I missed it.
Okay. So basically that concerns a proposed modification of the current rule, the emergency rule that was adopted in March versus the rule that is proposed here today. The current rule specifies that the department must essentially issue a notice of the hearing, of the scheduling of the hearing, identifying the hearing officer, the time and date of the hearing, and so forth. That the department must do that within what is effectively 5 business days of when the agency receives the request for hearing. And that is proposed to be increased to a maximum possible of 20 calendar days. And the reason for that relates to what we've been experiencing with the current declared emergency and COVID, in which public buildings, government buildings, have been closed, and in which employees, basically all of the employees of the Department of Health, are working from home. And what we've experienced is that there's pretty sporadic staffing as far as administrative positions, and so we're experiencing delays both with administrative staffing and then also with the agency's mail room. I suspect it's a similar situation in various agencies, such that the delays are such that the time that the U.S. Postal Service drops off a piece of mail at the agency's building is in some cases very different from the time that administrative staff actually see the request for hearing in this case and can act from that. And so that's what that proposed modification is intended to address.
So 20 days after it's going to be 20 days after they receive it, though. Or is it 20 days after when it's delivered to the office?
Yeah. So the date that's basically unchanged. That whereas right now it's 5 business days after the date that the Postal Service delivers it to the office. This would make it 20 days after the date that the Postal Service delivers it to the office.
And one last thing, I just want to make sure this is clear. So you're establishing an administrative appeals process there really wasn't one in place before. You're not modifying an existing one.
Yeah.
Before somebody was fine, and there really wasn't recourse. Now this is an effort to set up a system for that.
Well, so basically, this is a new rule, and the rule, the emergency rule that was adopted in March, was a brand new rule.
Mm-hmm.
And I think the short answer to that is that the Public Health Emergency Response Act, as far as I'm aware, was never utilized prior to COVID. It was adopted some time ago, I think maybe 20 years ago, but there had never been a circumstance that required it to be implemented. And so at the start of COVID, with the declaration of the public health emergency, we realized that this is something that we were likely going to need to utilize. And so the Public Health Emergency Response Act itself does describe, it references the creation of a rule for this purpose to basically just lay out what the hearings process for this looks like.
Okay. So I guess that's basically that. So up till now, like you say, the business was fine for operating unlawfully, like during the shutdown. Then the business owner didn't really have a way to appeal, and this is a way to create that.
Well, this is a continuation of, as I mentioned, there was an emergency rule that was adopted in March. And prior to the adoption of that emergency rule, there had been no such actions. But yes, the purpose of the emergency rule and the purpose of this proposed rule, which is substantially the same, is to identify the process by which those hearings occur.
Okay. All I was asking is if there was any kind of existing system in place. I just want to know how to frame it. That's all.
Yeah.
So there.
So this is the proposed rule 7.1.30, and it proposes certain modifications to the existing rule. But yes, there is an existing rule that was adopted in March, 7.1.30 NMAC, that as I say, is substantially identical to this one.
Oh, so this is just this is just adding these changes that you mentioned today to, all right. Okay. Thank you.
All right.
Do we have any additional comments?
We have, let's see, looking at our list of participants here, I see that we have at least, it looks like we have one individual who has called in on the telephone. I think that they had joined us later. If you can hear us on the telephone there, if you have any public comments to offer, please go ahead.
Yes, this is Carter Harris, and I'm an attorney out of Albuquerque, and I'm the party attorney for the Republican Party of New Mexico. I just wanted to offer briefly some public comments. First, to note that FARA was modeled after the Model State Emergency Health Powers Act, which was a CDC creation in the wake of the 2001 terrorist attacks on the World Trade Center and the Pentagon, heavily opposed by the ACLU and a number of other civil liberties organizations, and heavily modified from its model state into what we call FARA, where virtually all of those modifications are in the direction of giving enhanced procedural protections and some substantive protections to individuals subject to the Act or seeking to be penalized under the Act. And I guess I would ask that we take that spirit into the rulemaking procedure for FARA's penalty provision. And then I wanted to briefly comment on two of the proposed red line changes, and then one thing that I think is conspicuously missing. First off, to echo what the previous commenter said, I think requiring proposed findings of facts is not in keeping with an administrative process that is probably expected to largely be one used by pro se litigants. Mr. Erickson, I think, implied that there are other administrative procedures out there that require this. I'm not familiar with that. I know there are certainly administrative hearings procedures that don't require the submission of proposed findings and conclusions. What I would suggest is I guess clarifying to say that the hearing officer may solicit them, but cannot penalize a litigant, particularly a pro se litigant, for the failure to submit proposed findings and conclusions. And all I'll add is that the administrative hearings process, really the one virtue is supposed to be that this is a usable process for pro se litigants. Secondly, we oppose the changes to the in-person hearing requirement and would ask that the current red line be replaced by language allowing either side, upon request, to obtain leave from their own personal attendance, but providing a right to personal attendance to anyone who seeks it. So if the state wishes to seek leave to appear telephonically or videophonically, that's fine. If the fined individual wants to seek leave to obtain, seek leave to appear telephonically or videophonically, that's fine. But forcing telephonic or videophonic only hearings onto litigants who have been drawn into this process against their will is not consistent with the normal due process afforded in any other context that I'm aware of. Excuse me. And even now, in judicial proceedings, the final merits hearing is, you can wait till a time when you can appear in person. So we would oppose those two changes. And about the third thing that I wanted to add is that we would appreciate the inclusion of some language, or if not the inclusion of actual language, then a statement by the hearing officer in the final product that the hearing officer produces to the secretary, clarifying that the hearing officer in these adjudicatory proceedings has the authority to lower the amount of the fine while still finding the individual responsible. And what I mean by that is, my understanding is, to date, the DOH secretary has been issuing fines at the $5,000 cap. The statute says up to $5,000 per violation. And the secretary has largely assessed that, if not entirely, as being a $5,000 per day fine. And whether or not that's appropriate for the secretary to do in the first instance, we think that it should be made clear that the hearing officer has the ability to say, well, you're responsible for, not wearing your mask while jogging on the bosque, but that's not a $5,000 offense. I'm fining you $150. And I think that language like that would be helpful to have explicitly included. It's really not clear from the rule as currently written, but even if there isn't the appetite to add in explicit language, something in the form of an interpretation of the existing rule, I think to that effect would be appreciated. Thank you.
Are there any other additional public comments?
Mr. Erickson, it looks like we've covered everyone on the call. I see that we've got another DOH OGC member on the call, but as far as members of the public, I think we've covered everyone.
Okay.
I have additional comments offered.
I'm not taking any additional comments, Mr. Marcos.
You've got $5 set aside for a hearing, and you won't take any additional comments.
Okay. Briefly, what is your additional comment?
Okay. Do not say, I'm trying to say this very clearly. You're presenting, and in response to the question of this other gentleman, you presented this proposed document, 7.1.30, as if it were in place, and you're just proposing a modification to it. That is not the case. This document was introduced in an emergency hearing with no public input therefore to treat it as an existent document which is being modified is just absurd. The thing you should be doing is treating this document as a newly presented document, which is what it is, and working through the document very carefully, section by section. And you've chosen not to do that. That directly violates what you should be doing. The other point I'll leave you with, since I won't be allowed to comment anymore on it, hearing is that you're not using the default hearing procedure, and that itself is illegal. And you seem even unaware of that procedure, sir.
Mr. Meckles, you're repeating your earlier comments, and I'm going to close the public comments now. And thanks to those of you who participated in this hearing today. What happens next is that I will review all the evidence, I will review the comments made today, and then I will make a written recommendation to Secretary Kunkel regarding the proposed rules. I anticipate having that done by August 21st at the latest. So anything else, Mr. Woodward?
Just to repeat again, as the hearing officer had stated at the beginning, we will be receiving written comments until the close of business today. So if there was anything else that anyone wanted to add or anything that perhaps you hadn't thought of that occurs to you later today, by all means, please submit that to our email address identified on the notice, and we will be sure to get that to the hearing officer. And that's all I have.
Okay. Thank you. And with that, the hearing is now closed.